Good morning, you're Jaden Simon,
Yeah, tomorrow.
and this is 25 DCCR 1760. Mr. Simon's charged with aggravated robbery, and 25 DCCR 0918 charged with robbery. So the first one's aggravated robbery, second one is robbery. And what is the announcement?
Judge, he's rejecting the previous offer. It was 20 years. Told him that he could go and agree to the court, and also told him that because he wants probation, I also told him that the prosecutor is saying that they will, if they have tried, they will ask for an consecutive sentence.
That's exactly right.
So the offense dates are on two different dates. It looks like the first one was from June 12th of 2025, and then the second offense date from October 10th of 2025, which means if you're found guilty in both of those cases, it is possible the state would ask, and then it would be up to me whether or not I would run any sentences consecutive or concurrent, which means either stacked or not. So that would be up to me. It looks like you previously rejected, and this rejection might have been before. So it was 20 years in both to run concurrently. Is that correct?
Yes, Your Honor.
So the offer is a 20-year sentence in each of your cases to run concurrently. You want to continue with that rejection and move forward with trial. Is that correct?
Yeah, wow.
Okay, we'll get it set on the trial docket, and Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff.
Thank
Mr. Coleman, Mr. Adams is unable to be here this morning on John Lamel, so we'll reset John Lamel. All right, good morning, sir. You're Lenny Ledette. Ledette, I'm sorry. And Mr. Ledette's case is set for trial to begin with jury selection next Monday. And what is the announcement?
Thanks, ready, Your Honor.
Judge, we're ready subject to the case that I have set in another county, and I've spoken with him about it.
All right, so I'm going to contact that county, kind of see where we stand after this. I want to make sure we're all on the same page because after today, there won't be any plea negotiations or agreements. And it looks, have there been any new negotiations or?
Yes, Your Honor. Last week I filed a notice of enhancement using his prior to enhance if he's convicted of this offense, his punishment range will be that of a first degree. So at that time I made an offer for him to plea open to a second degree, just under the indictment count one.
All right.
And I believe that's been rejected.
And it looks like that prior that Mr. Nichols filed is regarding an aggravated robbery from September 27th of 1997. And so I'm sure Mr. LeBlanc has gone over with you, Mr. Ledette, that if you're found guilty in this case and that prior conviction is true, that would enhance your punishment to that of a first degree felony, which is between 5 years and up to 99 years or life in prison. You understand?
Yeah.
And do you want to reject that and go forward with your trial?
Yes.
All right, I am going to number this case the number one case. It's obviously the oldest. Mr. Ledette's in custody. It's time to get it moving. I will contact Judge Thomas and see if we can work that out, and we'll let you know today between he and I and who kind of wins out on that one. Okay, so we'll do our best to get your case tried next week. All of who gets which attorney depends on the type of case, age of the case, if the defendant's in custody, and all kinds of things. So I'll talk to Judge Thomas and we'll get that figured out today. Well, if Judge Thomas wins, depending on age of case and type of case, then yes, there would have to be a reset because Mr. LeBlanc can only be in one court at a time. If I win, then we get them and we try your case next week. So we'll find that out today. I'll talk with Judge Thomas. I'll do the best I can. I'll want your case tried this next week as badly probably as anyone. It's one of the oldest on my docket, so it's time to get it taken care of, obviously. So I will do my best to get Mr. LeBlanc here next week, and we'll know that today. Okay? All right, go back with the bailiff. Good morning. You are Judson Jermaine Bell.
Yes, ma'am.
And Mr. Bell has three cases, 25 DCCR 0108, 0109, and 0110, all set for trial to begin with jury selection next Monday. And what is the announcement?
Ready, Your Honor. That's ready.
And what is the intention with regard to, it looks like it's all the same offense date. What's the state's intention with regard to which case or all cases?
We'll be trying the evading case.
Okay. All right. So that is 0109. I will number the case today after docket and let you know after lunch
Yeah.
today. I do want to, it looks like there's been a plea bargain rejection on file for some time. That was for a so Mr. Bell, if found guilty, we've gone over this before, you would be considered a habitual offender because of your prior criminal convictions. And the offer was for a 25-year term, which is the minimum for a habitual offender. And you have, again, every right to reject that and go forward with trial. Is that what you want to do?
Yes.
All right, we will,
Actually, I
again,
think the state had offered 20 in this case, Judge.
had you, there
Yeah.
might have been one that was fell off that maybe you didn't do a new
Maybe, I
rejection.
think it was before the last trial docket, they dropped down to 20, but
Okay, so anything other than the 20 today?
no.
All right, so it would be a 20-year offer if you wanted to take that. Okay, we'll get it set for, I'll number the case after docket and let Mr. West know. Thank you.
He has a conviction.
There's two, there's an assault to third degree from September 11th of 2019 in the indictment. And then a prior one, attempted robbery, third degree, March 28th, 2013.
Yeah, I was looking at the unlawful possession of a firearm indictment. I don't know that both of those are priors were included in that particular.
No, it's not. It's not, Judge. It's just as one of them in that case.
But if there are two, you would
Right.
file that notice.
would,
So it would be considered habitual, correct? Okay.
Eventually I will.
Okay. All right, so are you Kendrick O'Veal?
Yes, ma'am.
And Mr. O'Veal, in cause number 25 DCCR 1776. Sorry, it's taking. You are charged with evading arrest or detention with previous conviction, and that's on August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. You're charged with a third degree felony offense of deadly conduct, discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because it state jail is the head.
Oh, I opened the wrong one. Sorry. Hold on. Y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all three cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you? And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. O'Bill, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. O'Bill, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. O'Bill, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you. Good morning. Are you Howard Walker Jr.? And Mr. Walker, in cause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment is 5 years, up to 99 years or life in prison. Do you understand? And I have here on the tablet a document called the plea bargain rejection that has your signature on it with Mr. Parker's. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case for a 30-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Nicholas, is there any reason to believe that, are you waiting on any evidence?
Judge, that offer is based on the injuries sustained by the child, a 1-year-old with facial fractures and lacerated liver. I need to get some follow-up medical records to see if that condition has improved or if it's going to be a permanent injury situation. That offer may get worse depending on what I find.
Okay, so I do want to make sure you understand, Mr. Walker, that after today, I will not accept this plea agreement unless there's some new evidence that comes to light from your attorney or the state's attorney. Do you understand?
Yes, ma'am.
All right. And so also, Mr. Parker's been appointed to represent you. And he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Parker, you're released. Mr. Walker, we will appoint someone today and they should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
Just takes forever to get rid of it.
Good morning. Are you Michael Martin Jr.?
Yes, ma'am.
This is 25 DCCR 1831 and 1832. Mr. Martin is charged with evading arrest or detention with the use of a vehicle and aggravated robbery. And Mr. Smith, what is the announcement?
Yeah, I'm asking for another. I was out all last week, but there's like 9 or 10 videos. I've had the discovery for a couple of weeks, and I just haven't had time to go through it completely.
Sure. So I'll just do a normal reset. Mr. Martin, that'll give Mr. Smith time to go through everything, bring it out to the jail, go through it with you, and then we'll see if we can get an announcement. All right, you go back to the bailiff. Thank you. Good morning. You are Dondre Blewett.
Yes.
And so we've got two cases here. We've got cause number 22-41150. And in that case, pull that please. Mr. Blewett is on probation and All right, so it's an evading arrest or detention with the use of a motor vehicle, third-degree felony. It looks like placed on probation September 13th of 2023. And that was an 8-year deferred probation. There is a first amended motion that's been filed. It alleges, looks like a new offense of aggravated assault with a deadly weapon from February 1st of 2026. Out past curfew, committing an offense of harassment, February 1st of 2026. Avoiding injurious or vicious habits by brandishing a loaded firearm during the assault of Ms. Cantu on February 1st, 2026. That he brandished the firearm at the residence where a child was present, same date. Associated with a disreputable person, Mr. Daniel Clark, who was at that same location during that offense or alleged offense. Failed to immediately report that arrest for the aggravated assault with a deadly weapon to the probation officer, was intoxicated or under the influence of an intoxicating substance on that date, possessed a firearm and ammunition in violation of probation on that date. And Mr. Kelly has filed a motion asking that I set bond in that case. And at this time, is there any bond set?
There's no bond set in the MTRP, Your Honor,
Okay.
and the bond in
Yeah.
the new indictment is $800,000.
All right, so in cause number 26 DCCR 0632,
And if I may, Judge,
hold on. Let's see.
thank you.
In that case, Mr. Blewett is charged with aggravated assault with a deadly weapon, second-degree felony, and that's from that February 1st date in 2026. And so the $800,000 bond was attached to that case by the magistrate when he was indicted. And Mr. Kelly has filed a writ in that case asking for me to reduce that bond.
Right, and if I'm not mistaken, Mr. Blewett had originally posted the bond after that February 1st arrest. He has not been incarcerated since February the 1st. He was released from Jefferson County Jail, I think on February 3rd or 4th after that initial arrest.
Through accusation or through making the $800,000 bond?
That's correct.
He got out on accusation,
That's
so he hasn't made a bond in anything.
That's correct.
Affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. And you can step up just a little bit. All right, go ahead.
Thank you, Judge. Officer Stelly, would you state your name for the record, please?
Deshauna Stelly,
How are you employed?
Jefferson County Adult Probation.
Okay, and how long have you been at probation?
Approximately 1 year and 4 months.
How many folks are you currently supervising?
150.
Is Dondre Blewett one of those people?
Yes.
How long have you been working with Mr. Blewett?
For the 1 year and 4 months.
Okay, since you've been here.
Yes.
Okay. Did you inherit his case from another officer?
Yes, sir.
Is that a normal thing that happens?
Yes, sir.
Okay. Would you tell the court, please, you can estimate, or if you know the actual number, how many specific meetings as Mr. Blewett's officer have you had?
Maybe 10, roughly 10 or 11. We do it every other month.
Every other month.
Yes.
Is it customary for folks that are on felony probation to only be required to meet every other month?
If they're in compliance, yes.
Has Mr. Blewett been in compliance up until this alleged new offense?
Correct, yes.
Okay. When you meet with him in person, those meetings are in your office? Is that
Yes,
correct? Okay. Is he on time for those meetings?
Yes.
Can you recall any situations where he has been late or kept you waiting?
No, sir.
Okay. Has he been respectful to you during those meetings?
Yes.
Has he been respectful to other staff in the probation office?
Yes.
Has he been subjected to drug testing while he's been under your supervision?
Yes.
Can you tell the court how many times he's failed a drug test?
He has never failed any drug test.
Has he been subject to any other kind of chemical testing?
No, sir.
Okay. In terms of other things that he's required to do or that he's been required to do while he's been under your supervision? Because you mentioned that he has otherwise been in compliance. I'm not addressing the February 1st issue yet. What other things has he been required to do other than not test positive for drugs and meet with you?
Community service, which he has completed, and fulfill his monetary requirements, which he's also currently those as well.
Which requirements?
The monetary.
Okay. So he is
Currently.
up to date on everything.
Correct.
Is that correct? Okay. Do you know where Mr. Blewett completed his community service?
He did some donations to some other place. So he completed 150 hours, and the previous officer held the other 150 hours in the bank.
Because he had completed those hours.
Yeah, within his first year of probation. Yes.
And that was within 3 years of an 8-year term. Is that right?
His first year. It was completed within his first year.
Understood. Where was Mr. Blewett working at the time that you started working with him?
Tesla.
What kind of job did he have?
I'm not sure exactly. Just with the cars. I know that he had a travel permit to travel, in and out. So I believe he was going to Austin, I think, to work. So we gave him a travel permit, permitted him to travel. I had no issues with him.
Okay. He was working diligently as required. Is that
Yes.
right? Okay. At the time of his February 1st arrest, were you aware that he had another job offer pending
Yeah, it's from ExxonMobil.
locally?
Yes.
Okay. Do you know what kind of work that was going to be?
No, I told him that he could forward me over the documents from the person who offered him the job. He sent it over to me. The issue was that he was on probation. So I told him that early termination was a possibility because he was in compliance. So I believe since he had an 8-year term, it was about 2 years and 8 months, I believe. So he was coming up on that in March. So we were going to look at early terminology so we could get that job.
He was otherwise eligible to at least petition the court for it.
Yes, correct.
Okay. When you first discovered, let me ask that a better way. When did you first learn Mr. Blewett was arrested on this February 1st allegation?
I received a flash notice on February the 6th.
The next day.
Yes.
When was your first contact with Mr. Blewett after the February 1st arrest?
So he came to report immediately upon his release, which was on February the 5th.
Did he tell you got arrested?
Yes.
Okay. Can you tell the court what your reaction to what was to his arrest?
I was shocked because he never gave me any issues during his time on probation that I've been working with him. So I was very shocked.
Have you had further meetings with him since that initial contact?
No, it was just a meeting between me, him, and my supervisor. And since he was out on the accusation, we were just telling him not to contact the victim. And that we did have to file a motion because of the alleged offense and that a warrant will be coming out. So.
Any other things covered in that meeting between you, Mr. Blewett, and your supervisor?
No.
In the time that Mr. Blewett was released on accusation and this new warrant was generated, was he otherwise in compliance for that short, maybe 8 or 10-day period?
Yes, sir.
Are you aware, one way or the other, if you don't know, then you don't know, as to whether or not he's had contact with Miss Cantu?
Not that I'm aware of, no.
Are you aware, one way or the other, whether she has attempted to contact him?
No.
Okay. If he were, if Mr. Blewett were to make new bonds on each of these cases or otherwise be released, you would expect him to report to you immediately, correct?
That was correct, yes.
Are there any other modifications you would make at this point if he's released?
No, sir.
Do you have any concerns that he would otherwise be compliant under your supervision?
I have any concerns, no. I believe that he can be compliant.
And you don't know anything about this new allegation, is that correct?
I did not speak to him about it, no, sir.
Have you spoken with the officers involved in the arrest?
No, sir.
Have you spoken with the alleged complaining witness in
No,
the
sir.
arrest? Have you spoken with the state's attorney, Mr. Coleman, about the new case?
No, sir.
Have you spoken with anybody in the district attorney's office about the new case?
No, sir.
In fact, you, when you first learned about the new arrest allegation, you, I suppose, checked the Odyssey system. Is that correct?
That's correct. Yes.
And you learned that the case was refused. Is that correct?
Yes.
Do you know why it was refused?
I am not sure. I received a letter from the district attorney's office saying that the case is going to be refused. So further.
If I told you that I've learned that it was at the request of the complaining witness, would that be you wouldn't have any reason to disagree with that, right? Okay. When did you learn that the case had been indicted?
This morning.
Today?
Yes.
Yes, witness, Joe.
I have no questions for Ms. Stelly.
Thank you, ma'am. Any other witnesses?
Not from us, Jennifer Bresser.
All right, Mr. Coleman.
Your Honor, I filed a reply. I'm sure the court's taking a look at.
I have.
the reply. Your Honor, at this time, I would ask or submit to the court for your consideration a compilation of snippets of a 911 call and 2 body cams. Just to kind of set it up for the court. That 911 call was about 8 minutes long, but I'll cut it down to about 4 minutes. I think all of those 4 minutes are kind of relevant for the judge's consideration this morning. And of the body cams, which were both more than an hour each, I've cut it down to about 2.5 minutes each. Just so you know, the entire clip or video is about a little less than 10 minutes long. But I try to cut it down just to what I think the court should consider or need to consider.
Mr. Kelly.
It's my understanding that the state's attorney doesn't intend to call the alleged complaining witness or any officers involved. So we would object to the admission of whatever this is without it being authenticated.
Judge, the rules of evidence are relaxed in these bond hearings.
They're relaxed. They're not no rules.
Yeah, I don't think there's, I don't think I can just help me find the spot where I can
The
over
rules of
object.
evidence for these bond hearings or at a minimum, they are relaxed, is my understanding with of the procedural posture for these hearings. I've played these videos for the court in these bond hearings before without a sponsoring witness, Judge.
Well, and if it was without objection, then that's one thing. But if there's an objection, then my thought would be we need to now probably one. I would be willing to say one officer who could set up and look at both. I would be willing to not require, I think, the same amount of information. But I don't think they're so relaxed that I can just watch whatever.
That's fine, Judge. We ask that you recess this
Yeah.
at least for a little later in the morning, or I'll endeavor to make my best efforts to get the officer here to sponsor it. I will purport to the court that what you will hear on that 911 video is a 7-year-old daughter of the victim.
Well, and 911, if you can get one officer here, I think they're, in my opinion, for this type of hearing, they are well enough informed about how that works that I don't think I'm not going to require, if you can't get a 911 operator here or somebody from that office quickly, if you can get an officer that can testify that the other officer's body cam, he was also there potentially. I think relaxed to me for this type of hearing would mean that. So I'm willing to give you some leeway on all of that if you can get someone here. So I'll hold it.
Yes, please.
Make some calls, see if you can get them here this morning. If not, we are here this afternoon on another hearing. We can work around that so that we can get to it today. What is your schedule like?
I have a hearing in another county, but this is a priority. So
Okay, well, let's just see where Mr. Coleman can get with getting just one of those officers here. All right, I'll hold it. Morning. Are you Caleb LaFleur?
Yes, ma'am.
This is 26 DCCR 0039. Mr. LaFleur is charged with theft of property. First degree felony, November 14th of 2025. And what is the announcement?
So, Your Honor, if we could get one more reset, it's indicted as a first degree, stating that the value is $300,000 or more. It appears in the reports it may be $30,000. So that's a drastic difference of
Sure.
what this could potentially be. So if we could get a reset to make sure that that is accurate, and if so, then obviously that indictment may need to be amended.
And
The state would like the opportunity to do a little investigation. Yeah, Ms. Holmes is correct. In the offense report, there's a $30,000 claim. And I don't know if the extra zero was a typo that just fell down the line, but I would like an opportunity to investigate.
do you have any other holds on you
On different hardship.
from Calcasieu Parish? They have a hold on you?
Yes, ma'am.
Okay, so let's just do a normal, I'll do a normal reset. Now, if something happens and you guys figure out that it is 30 and there is an amendment to the indictment, let me know, because I think it would make some sense, depending on other criminal history, maybe not, to at least look at that bond
Yes, ma'am.
that's set in this case, okay?
Okay.
All right, you can go back with the bailiff.
And just like that, the courtroom delivers another intense twist. Ava Musgrove walked into this hearing facing an overwhelming $800,000 bond on a murder charge. But after emotional testimony, deep questions about her past, and a former Texas Ranger raising the possibility of self-defense, the judge made a major decision. The bond wasn't dropped to the $50,000 the defense wanted, but it was cut to $500,000. That's a huge shift, and it changes everything moving forward. Now, here's the real question. Was this truly self-defense, or is there more to this story than we've heard so far? That's what the trial will have to uncover. One thing is clear, this case is far from over, and every hearing is revealing new layers. The stakes are high, the truth is complicated, and the next courtroom battle could change Ava's life forever. What do you think? Should the bond have been lowered even more, or did the judge make the right call? Drop your thoughts below and stay tuned for the next update, because this case is only getting started.